What you are about to hear is the result of hundreds and even thousands of people who have donated their time, money, and support to me and my family. In the last decade, I have learned many hard lessons in my journey through the legal system. I've learned that there are many judges, lawyers, prison guards, and cops that do their jobs with integrity. They respect laws, due process, and constitutional guidelines. They understand that a just result from the judicial process is dependent on them doing their jobs, and many of them hold their colleagues to that same standard. As you will hear, I wasn't lucky enough to have any of these people involved in my case. When I first walked into the courtroom, I assumed I would receive a not guilty verdict simply because I'm innocent. Unfortunately, I soon found out how far outside the law the judge and prosecutor would go to ensure that that didn't happen. I have many goals with this whistleblower complaint, but at the top of this list is to raise awareness to any other innocent person about what you're really up against. At the end of this video, you will be provided with a few things that you can do to help end this corrupt practice and let your voice be heard, and it won't even cost you a dime. Remember while you're listening, these people's paychecks come out of your tax dollars, and the actions they take represent you. Let them know in a calm and peaceful manner what you think about how they use the power and authority that you give them. I want everyone to know that even though I have Ms. Zellner brilliantly fighting for me in the federal courts, I still need each of you to stand up and call out and stop this corruption. Again, thank you for watching. Thank you for caring. And I want to thank my friend Bob for offering to record the reading that you are about to hear. Thank you.
Hello, friends. I have in my possession an 8-page letter and 4-page appendix from Tim Guilfoy. Tim was accused and convicted of crimes he did not commit in the state of Tennessee. This letter is addressed to Representative Justin Lafferty, a chairman of the Joint Government Ops Sub of Judiciary and Government Committee. It's also been sent to the Tennessee State Attorney General, the Davidson County Attorney General, the United States Attorney General, the United States Department of Justice Civil Rights Division, and all Tennessee state and United States legislators, as well as the Tennessee Bar Associations. This is the whistleblower complaint on illegal jury tampering by Tennessee Judge Monte Watkins. Dear Representative Lafferty, my name is Tim Guilfoy. I am currently an inmate at Northwest Correctional Complex in Tiptonville, Tennessee. I was convicted in Davidson County in 2011 of crimes that I did not commit. However, my innocence is not the main subject of this letter. Since I was convicted, I have discovered my conviction was secured because Criminal Court Judge Monte Watkins allowed a presentation of additional information to the jury during the deliberation of my case, which was not presented in the courtroom during my trial. This presentation was not on the record. Neither I nor my attorney were notified by the court that this presentation took place. I never had the opportunity to view, object to, or cross-examine the content of the presented information in any form or fashion. Judge Watkins tampered with my jury by exposing them to extraneous information, something not evidence in my case, and then covered it up by not telling anyone about it or enshrining it on the trial record in any way. I realize this is an extreme accusation that must be corroborated with incontrovertible evidence, which I have attached to this letter. I intend to prove to you not only did Judge Watkins surreptitiously tamper with my jury, but also it is highly likely he has done so with the juries of countless other cases, and may very well be continuing to do so to this day. After I prove this accusation in this letter, I will be requesting you use your authority as a representative of this state to investigate and stop this fraudulent and illegal abuse of power by Judge Watkins and the Davidson County District Attorney's Office. I am submitting this whistleblower complaint to comport with the Tennessee whistleblower law. While you may not consider me a quote-unquote state employee, as defined in the statute, I am currently in state custody and am requesting similar protections against the likely retaliation for the submission of this complaint by the parties named herein, as well as any retaliation by Tennessee state employees and offices not mentioned in this complaint. Before I get into the body of my complaint, I want to address a few things. I want to make it clear I intend for many people to read this letter, and toward this end I need to ensure that each person reading it understands a few basics about due process. In the state of Tennessee, as well as everywhere else in this country, a criminal trial must comply with the rudimentary principles outlined in the Sixth Amendment of the United States Constitution. Prosecutors must present whatever evidence they are giving to the jury in a public courtroom where the defendant can have the opportunity to defend himself against it. Juries may only consider the information presented to them in the courtroom during the trial. Even accidental jury exposure to prejudicial, extraneous, or outside information is such a fundamental error that it automatically causes a mistrial, and the prosecution must start all over again with a new jury which has not been tainted. If someone intentionally exposes a juror, much less the entire jury, to information not presented in the courtroom, it is a crime. In fact, it is a felony. Society trusts trial judges more than any other figure in government to follow both the letter and the spirit of the law. They are entrusted with many things, including protecting juries from exposure to extraneous information and influence. This is why my accusation that Judge Watkins violated multiple laws, and therefore the public's trust, carries such a high burden of proof on my behalf. This is also why you, as a member of the legislature, must take this accusation seriously. The public puts such a large degree of trust in trial judges not to do what I am about to prove to you Judge Watkins did, that I implore you to take decisive action against him without delay or bias. Anything less will belie the professed integrity of the entire Tennessee judicial system. This complaint is divided into two sections, about 3 pages each. The first section briefly covers what has happened in my case from my perspective to put my accusation into context. You can learn more about my case by visiting www.freetimg.com. The second section covers my accusation in more detail and explains exactly what I am asking you to do with this information. I have spent the last 9 years both surviving in prison and also fighting my case under the very intense restrictions that accompany my imprisonment. This letter represents years of work and a massive amount of effort and expenditure of resources from me, my family, friends, and supporters. I submit the least you can do is take the next 30 minutes and carefully read the next 6 pages. I make no wild accusations. I am only presenting facts supported by publicly available information. You will likely notice I am repetitive in this letter. This is because I have found those in charge of my case over the past 9 years have relied upon a selective ignorance of the inconvenient facts in my case. I am relying on the assumption and the hope that you respect objective facts and genuinely honor your oath to uphold and defend the Constitution. By the end of this letter, I hope you at least believe this complaint is only the beginning of my effort to alert the public to Judge Watkins' extremely unconstitutional practices in his courtroom. The oversight I am asking you to perform will surely be unpopular in some circles in the Tennessee government, but nonetheless, it is vital to protecting the basic constitutional rights of every one of your constituents. An abbreviated history of my case. Trial. In 2009, I was renting a house to a woman whom I believed to be a friend. She and her family had been living in the rental house I owned for about 6 months, but had failed to pay at least half of the rent payments. After giving her 2 weeks to pay thousands of dollars of back rent or face eviction, she called the police and accused me of sexually abusing her 3 minor daughters. Without any physical evidence or any investigation or corroborating evidence whatsoever, I was arrested and charged with dozens of Class A and B felonies. She continued to live in my house rent-free for months and did not take her children to a medical professional until over a month later. My first trial occurred in July of 2011 in Judge Watkins' courtroom, but ended in a hung jury due to the fact that I was able to rebut all the evidence and also produce alibis for every date that I was alleged to have been committing these crimes, the vast majority of which I proved beyond any doubt I was in other states. This trial ended in a hung jury with half of the jurors refusing to vote guilty on any charge. After the mistrial, I refused multiple plea offers from the prosecutors, including a deal only requiring probation. I refuse to plead guilty to crimes I did not commit. My retrial took place in October of 2011. I was again able to successfully refute all of the evidence and argument presented in the courtroom. However, I was still convicted of every charge and sentenced to 70 years in prison without parole, despite having no criminal history whatsoever. After the trial, my family hired a private investigator named Charles Blackwood to begin the long, laborious process of appealing my verdict. During the course of the investigation, Mr. Blackwood was able to track down most of the jurors and ask what evidence shown in the courtroom persuaded them to convict me. To our astonishment, every juror he interviewed had the same answer: none. According to them, the only reason they convicted me was because they all watched 2 videos of pre-trial interviews of the alleged victims which convinced them to vote guilty. You can see the juror interviews at www.freetimg.com/interviews. 2 major problems arose with this. First, no videos were included in my pre-trial discovery packet. And second, No videos were ever played during my trial in the courtroom. This meant that the jury considered information that was not evidence in my case. Neither my lawyer nor I had any idea how the jurors were able to watch the videos. Judge Watkins did not inform us at any point during deliberation that the jury was watching any videos. In fact, there had been no notification from the court of any jury request or presentation at all during the deliberations. No juror told us at that time how they were able to view these videos, only that they based their verdicts on them. At this point, no jurors agreed to sign an affidavit about viewing the videos, and we had no legal ability to compel them to do so. 2 weeks after the trial, my new appellate attorney went to the courthouse and was allowed to view the videos provided to the jury and learned they were highly edited by the prosecutors. He was also able to view the original, unedited videos and realized that the prosecutors improperly redacted portions of the interviews seen by the jury in order to remove content proving the witnesses were not being truthful. Appeals. We appealed my conviction to the Tennessee Court of Criminal Appeals. We argued that the contents of the videos were not evidence in my trial, but that the jury watched them prior to their verdict nonetheless. The state attorneys argued that even if it was error to give the jury the recordings, the jury did not watch them. I have attached the relevant portion of the 2013 appellate court ruling to this letter, appendix, page 1. I encourage you to read it now and come back to this once you have. Direct appeal excerpt. Tennessee v. Guilfoy. Without objection, the trial court admitted as substantive evidence the recorded forensic interviews of J.A. and T.A. However, the interviews were not played in open court. Rather, they were made available to the jury during deliberations. Although the record clearly demonstrates that the trial court erred in admitting the recordings of the interviews into evidence, the record does not demonstrate that the jury ever watched the interviews. In order to watch the recordings, the jury would have had to request the appropriate equipment. The record contains no indication, however, that the jury ever requested the equipment, nor does the record contain any other indication that the jury watched the recordings. The record is simply silent on this point. Accordingly, the defendant has failed to satisfy the first prerequisite of plain error review. Additionally, because the record contains no indication that the jury watched either of the recordings of the forensic interviews, the defendant cannot demonstrate that the erroneous admission of this evidence adversely affected one of his substantial rights. Accordingly, the defendant has failed to satisfy at least two of the prerequisites for plain error relief. Therefore, we hold that the defendant is not entitled to plain error relief on this basis. The appellate court ruled, 1, that the trial court erred by giving these DVDs, or recordings, to the jury, and 2, that the DVDs were not played at any point in the trial, and therefore their contents were not evidence in the trial. However, they ruled that to view the DVDs during deliberation, the jury would have had to request viewing equipment, and the trial record did not, quote-unquote, indicate that this occurred. The appellate court trusted Judge Watkins to such an extent that the lack of a request on the record was considered decisive proof that no request was made by my jury. They concluded the jury therefore did not watch either of the extraneous videos. I was denied a new trial. I immediately filed a post-conviction petition in Judge Watkins' court. At the hearing in June of 2014, I subpoenaed the jury foreman to testify on how the jury came to be able to watch these videos. At this point, I was unaware how the jury viewed the videos if it was not in the jury room, as the absence of a request on the record indicated this was not how the videos were watched. Before the hearing started, Prosecutor Roger Moore objected to the juror even testify, saying, quote, "A juror may not testify, period," unquote. He further stated the appellate court ruled on what was already on the record, quote, "Not that we need more evidence on the record," unquote. Judge Watkins agreed and ruled the juror could not testify. My appellate attorney explained to the judge the appellate court ruled in my first appeal that the record indicated the jurors did not watch the videos. He argued that we were just trying to determine if they did watch them and, if so, how they did so, considering the record was silent as to any request for video equipment during deliberation. He asked if we could at least question the foreman as an, quote, "offer of proof," unquote, to establish the answers to these questions on the record. Watkins repeatedly denied this request and told the juror to leave the courtroom. Later in this hearing, my trial attorney testified that he was not informed of any presentation of the videos during deliberation. In the end, Judge Watkins denied my post-conviction petition. On appeal, the appellate court again denied me a new trial because there was still not enough evidence on the record to prove that the jury viewed these videos. See Guilfoy v. Tennessee, 2015, appendix to this letter, page 2. Even though I personally knew the jury watched these videos, I still had no idea how they did so, and there was no way for me to prove on the record that they had watched them. After both my direct and post-conviction appeals, I petitioned the state Supreme Court to review my case, but both requests were denied. New evidence. It was at this point in 2016 that two new attorneys joined my case. The first was Samuel Moldavin in Memphis, and the second was Kathleen Zellner in Chicago, Illinois. Miss Zellner is well known around the country as one of the top wrongful conviction attorneys practicing today. They hired a new investigator who was able to again track down many of my jurors. After jury foreperson Hillary Hoffman came to understand the videos were not evidence in my case, she agreed to answer our questions and to sign an affidavit about the jury viewing them because it was the main, if not only, reason most of the jurors voted guilty. I have attached this affidavit to this letter, and I encourage you to read it. Pages 3 to 4 in the appendix. State of Tennessee versus Timothy Guilfoy. Affidavit of Hillary Hoffman. State of Tennessee, County of Rutherford. Before me, the undersigned authority, did appear, Hillary Hoffman, who did depose and state under oath the following. 1. My name is Hillary Hoffman. 2. I am a person of the age of majority and a resident of Rutherford County, state of Tennessee. 3. On or about October of 2011, I was the foreperson of the jury sitting in the matter of the state of Tennessee versus Timothy Guilfoy. 3. Sitting in the courtroom during the course of the trial, I heard mention or discussion regarding videotapes that appeared to have been some related to the issues being presented to the jury. 4. The videotapes were never played in the courtroom during the trial. 5. After the jury retired to the jury room, I decided that it was important that the jury view the videotapes as part of our deliberation. Simply stated, I sincerely believed that the jurors had to examine absolutely every item of available information about the case in order to enable us to render a verdict that was true and fair. 6. Having decided that viewing the videotapes was necessary, I informed an individual who I believe was a court officer that the jury wanted to view the videotapes. 7. In response to my request, an individual who I believe was a court officer wheeled into the jury room a television, and a DVD player that were sitting on a rolling cart. 8. I cannot recall specifically who I informed that the jury wanted to view the videos. 9. I cannot specifically recall if the individual who I spoke to about wanting to view the videos was the same individual who brought me the television and the DVD player into the jury room. 10. After the television and DVD player into the jury room, they were set up by the person who brought them in. The DVDs were inserted, and the jury, gathering around the television, watched them. I'm going to read number 10 again, from the affidavit of Hillary Hoffman. After the television and DVD player into the jury room, they were set up by the person who brought them in. The DVDs were inserted, and the jury, gathering around the television, watched them. Signed, Hillary Hoffman, and notarized. Ms. Hoffman explained to us that she personally made a verbal request for video viewing equipment to a court officer during the deliberations, and the court officer then wheeled in a TV and DVD player and played the videos for the jury in the deliberation room. This was the exact request the appellate court concluded did not occur during the deliberation of my case, because the record was, quote, silent, unquote, about it. We promptly filed an error coram nobis, new evidence, petition to Watkins Court using this affidavit. We have since learned the court officer who received this request and brought the viewing equipment to the jury room was Stephanie Mosley. We supposed Officer Mosley perhaps forgot to mention this request to the judge, thus explaining why it was not on the record. We believed, naively, Judge Watkins and Prosecutor Moore would be truly surprised not only to learn the jury made this request, but also to hear it was granted. Mistakes happen, and my attorneys and I expect the judge and prosecutor to acquiesce to our request for a new trial, considering that the affidavit proved my jury was exposed to information not presented during my trial, and also because the lack of a request on the record was the basis for the denial of both my direct and post-conviction appeals. Sadly, we were wrong. Prosecutor Moore immediately motioned to dismiss the petition. At the March 2017 hearing, Mr. Moore admitted this request did occur, but claimed it was already, quote, probably in the record that at some point the jury asked to have recording equipment to see the video. That's nothing new. This statement completely ignored the entire past 5 years of argument by the state attorneys that this request was not made. This also ignored my first two appellate rulings' conclusion that no request was made because none was on the record. Judge Watkins agreed with Mr. Moore, again denied our attempt to question multiple jurors on the stand, and then dismissed our petition, stating, quote, all of the petitioner's issues have previously been raised and decided, unquote. Their statements at this hearing made it clear they were both fully aware this request had occurred throughout the entire previous 5 years of my post-trial appeals. This begs the question of why they did not correct the incomplete record earlier in my 2014 post-conviction hearing, especially when it was made clear the appellate court denied my 2013 direct appeal specifically because the record was, quote, silent, unquote, as to this request. Officer Mosley was also at the 2014 hearing, but said nothing as well. Roger Moore is an officer of the court, and he obstructed justice not only by withholding this information from the record in the 2014 hearing, but also by lying in open court when he made the above statement in this 2017 hearing. In 2018, the Tennessee Appellate Court upheld this dismissal, ruling I, quote, should have, unquote, appealed the judge's refusal to allow the juror to testify in my 2015 post-conviction appeal about this request, even though I had no idea this request occurred until 2016. To review what happened in my case. 1. No videos were played during my trial. 2. Two highly prejudicial videos were played for my jury during deliberations by a court officer. 3. Neither the judge nor the prosecutor recorded this presentation on the record in any way. 4. The appellate court denied me a new trial specifically because there was nothing on the record to, quote, indicate, unquote, these videos were watched by the jury. I was convicted of crimes I did not commit with evidence I've still never seen to this day. Then, after I was finally able to get an affidavit from a juror proving that the jury was in fact shown these videos, the prosecutor, judge, and appellate court blamed me for not earlier appealing the fact there was a granted request to view them, which the judge and prosecutor both actively withheld from me and from the court record, even preventing me from discovering through the juror's testimony at my post-conviction hearing. Does any of this sound fair to you? Additional remedies. I have filed formal complaints regarding this grievance with both the Tennessee Board of Judicial Conduct and the Tennessee Board of Professional Responsibility in the fall of 2018. The Board of Judicial Conduct refused to even conduct an investigation, stating my complaint, quote, appears to be a reflection mostly of dissatisfaction with a decision or a series of decisions made by a judge, unquote. Tampering with a jury, tampering with a record, obstruction of justice, and official misconduct are not just, quote, decisions, unquote. They are crimes. As for the Board of Professional Responsibility, they actually conducted an 8-month-long investigation, even though there was abundant evidence of ethics violation and a major conflict of interest by both the DA and my then appellate attorney. The Board of Professional Responsibility dismissed my complaint, stating they found, quote, no evidence, unquote. Any ethical rule was violated. You can read the entire complaint, the attorney's responses to the complaint, and the decision from the board at www.freetimg.com/BPR. I have exhausted every avenue available to me through both the executive and judicial branches of the Tennessee government. I am not a conspiracy theorist inmate weaving together a contrived narrative without evidence. You hold the proof in your hand that my jury was presented with information which was not presented in the courtroom during my trial, that it was Judge Watkins who allowed this to occur, and that Judge Watkins covered up this presentation to the jury. I have lost my freedom in years of my life, and I have never even been given the chance to see, object to, or appeal the evidence that caused it. Is this the standard of quote-unquote justice in Tennessee? Both the executive and judicial branches have answered this question clearly. Yes. I now turn to the legislative branch of the Tennessee government, and I ask you the same question. Is this what you call justice? I assume when you were running for your seat, you promised your constituents you would defend the Constitution and their God-given rights. What if the people who voted for you were told, you can be charged with a crime you did not commit, you can successfully defend yourself against all the evidence presented in the courtroom at your trial? But none of that will matter, because in Tennessee, the prosecutor can have the court present additional evidence to the jury during deliberation that you are not allowed to see, object to, or defend yourself against. You won't even be able to appeal the use of this evidence because Tennessee judges don't have to tell you about it or preserve its presentation to the jury on the record at all. This is not justice. What I am asking you to do. I am urging you to pressure the Senate and House Judiciary Committees to initiate inquiries into Judge Watkins' illegal presentation of extraneous information to my jury, as well as an inquiry into his possible criminal pattern of behavior in the other trials in his courtroom, past and present. Judge Watkins violates the law and then covers it up. From the records available to me here in prison, Judge Watkins has been on the bench for at least 16 years, and he has sat on hundreds of major felony cases, many of which resulted in life sentences for dozens of defendants. State law is very clear as to how he should handle any requests or questions from the jury once they have retired to deliberate. Tennessee courts have adopted ABA Standard 15-4.2 in Tennessee v. Jenkins, 1992, which absolutely requires the judge to call everyone back into the courtroom if the jury asks a question or makes a request. He must inform the prosecutors and defense counsel on the record of the question or request, allow for arguments and objections, and state for the record what action, if any, he will take in response to the request. This is only logical, since no one other than the bailiff is allowed back near the jury during the sensitive deliberation stage of the trial. Also, this standard ABA process preserves everything that happens on the trial record so the appellate courts can review what occurred in the trial. There have been numerous cases in Tennessee and around the country that have been overturned simply due to the judge's improper response to a jury's question or request. See Tennessee v. Flatt or the United States v. Gay. At the very least, these hearings also ensure the defendant is aware of the request or question. I have searched all the records available to me here at the prison. And do you know how many such hearings I have found to have occurred in the hundreds of Judge Watkins cases? 0. In all of his 16 years of cases, apparently there has been not one jury question or request made at all by any jury in his trials, according to appellate court rulings. Of course, you know this not to be true. You are holding an affidavit from my juror foreman in your hand right this second, proving this is not true. Any experienced trial attorney will tell you 16 years of cases in any courtroom would result in at least dozens of jury inquiries over time, as they are quite common. For comparison, I have found numerous appellate court opinions for every other Davidson County criminal court judge where they held these hearings to litigate a juror request or question during deliberations. A great example is from State v. Howard in 2010, where Davidson County Judge Cheryl Blackburn held a hearing about a jury request to view a transcript from the preliminary hearing that was admitted, quote, for identification purposes, unquote, at trial. Judge Blackburn explained to the jury that the contents of the transcript were not read into evidence at trial, and therefore they were not allowed to consider them during deliberations. The appellate court was able to review this decision because it was enshrined on the record with this hearing, and when the court upheld the judge's denial to the jury, finding her response to the inquiry lawful. Either Judge Watkins is unaware these hearings are required when a question or request is made by a jury, or he is maliciously obstructing the preservation of the records in his cases to avoid scrutiny of his responses to these jury inquiries. The public puts its trust in trial judges to ensure any inquiry happening during these deliberations is at least recorded on the trial record. There is statutorily no other safeguard to ensure these inquiries are recorded. There is likely no way to know exactly how many other improper jury requests have been granted off the record in Judge Watkins' other trials, or, in a similar fashion, how many proper requests have been denied. Either could be consequential to a defendant's future appeal. Judge Watkins might claim his failure to conduct these hearings is just a technicality, but as I stated earlier, there have been literally hundreds of cases where the response to a jury inquiry has resulted in the higher courts ordering a new trial. Even if he sincerely believes his responses to jury inquiries are proper, they still must be recorded on the trial record for appellate scrutiny. Failure to record these requests conceals even the existence of these requests, as illustrated by my case. My case represents the worst-case scenario of his failure to properly treat jury inquiries. My jury verbally requested to view something not presented during my trial, and this request was granted without a hearing, without the opportunity for me to object, and without any documentation on the record. Then, to add insult to injury, the appellate court denied me a new trial specifically because there was, quote, no request on the record, unquote. This was not just judicial error. It was extrajudicial jury tampering. Let me make something very, very clear. The contents of these videos were not evidence in my case. They were not given to me in discovery. They were not subject to any rules of evidence because they went through no evidentiary hearing as required by Tennessee state law. They were not played during my trial. I have never even seen them. In fact, the appellate court opined that the videos could not have legally been used for multiple reasons. Also, the videos were unfairly edited to the state's benefit. For the first 5 years after my trial, the state attorneys argued that the jury did not view these videos. After I obtained the juror's affidavit unequivocally proving not only did they view the videos, but also it was the court which allowed them to do so, the state attorneys changed their argument to say the videos were evidence in my case because the physical DVDs were entered as exhibits, and the jury was therefore allowed to view them during deliberation. However, the state appellate court has already ruled on this issue. In Tennessee v. Henry from 1997, the Tennessee appellate court ruled on a case very similar to my situation. Audio tapes were entered as exhibits in that case, but were not played during the trial, like the videos in my trial. The jury asked to listen to them during deliberations, as in my trial. The judge held a hearing in response to this request, unlike Judge Watkins in my case. In that hearing, he explained to the jury that while the physical recordings were exhibits, the contents of the recordings were not played during the trial in the courtroom, and therefore the jury was not allowed to consider them during deliberations. The Tennessee appellate court upheld this ruling, confirming for anything to be considered evidence in a case it must be first presented to the courtroom during the trial, including the contents of a recording. The federal courts have also weighed in on this principle. In United States v. Nashville, the Ninth Circuit Federal Court of Appeals stated, quote, playing unplayed tapes for the jury in the jury room is akin to allowing a new witness to testify privately, without cross-examination, to the jury during deliberation. In cases where the error is so fundamental and defies meaningful review, we have said that harmless or plain error analysis may not be applied. Instead, we find the error to be a structural error requiring automatic reversal. End quote. At my error coram nobis hearing in March of 2017, where we entered the juror's affidavit into the record, Prosecutor Roger Moore stated the judge in Henry was, quote, wrong, unquote. And the videos in my trial were evidence the jury was allowed to consider, even if they were not played during the trial. I believe the committee should inquire into what the Davidson County District Attorney's Office considers evidence. I hope these committees consider the drastic constitutional implication if the District Attorney's Office is routinely presenting information to juries that has not been either presented in an actual courtroom or even shown to the defendant. I'm sure the DA's office and Judge Watkins will act as if the jury viewing these videos was at most only a minor error in my trial. that it did not affect the verdict and that would not have overturned my conviction if it was enshrined on the trial record. Nothing can be further from the truth. Both state and federal courts consider jury exposure to extraneous information to be one of the few structural constitutional errors that assume prejudice and automatically results in a new trial for the defendant. See Tennessee v. Adams. Simply put, my appeals would have certainly been granted if Judge Watkins had properly enshrined the illegal presentation, or at least the request from the jury on the trial record. Most people have heard of trials being overturned because a juror read a newspaper article about the case or had a conversation with a witness at the lunch break during the trial. Even this slight exposure to minimal extraneous information or influence routinely causes a new trial, whether the defense finds out about it either before or after the verdict is reached. My jury's exposure was far from slight, and the information was as prejudicial as it can get. Judge Watkins essentially allowed additional testimony, edited by the prosecutors and unchecked by cross-examination, to be considered by my jury during deliberation. Not only were the contents of the videos in my case extraneous to the evidence presented in the courtroom, all of my jurors told us it was their main, if not only, reason they convicted me. Again, I still have not seen these videos to this very day. All of Judge Watkins' trial juries may have been tainted. The record from my case demonstrates that the presentation of extraneous information to a jury during deliberations is an acceptable practice in Judge Watkins' courtroom. The record also demonstrates that it is effectively official policy in his courtroom to inform neither the defendant nor his attorney of these presentations, nor must he even enshrine them on the trial record, contrary to Tennessee state law. I believe it is highly unlikely my case is the only one in Judge Watkins' courtroom where extraneous information has been presented to a jury during deliberations. As I stated earlier, there is no record of Judge Watkins conducting any jury request or question hearings in any of his 16 years of cases. The defendants from all of Judge Watkins' other trials would likely be unaware of the existence of unrecorded jury inquiries in their trials if they did occur. The only way I found out about what happened in the deliberation room in my case is that my family paid thousands of dollars to a private investigator to track down the jurors, and then I was lucky enough that the jurors randomly told him about the viewings. In the 9 years since I have been locked up, I have met thousands of other defendants and have helped hundreds of other inmates with their cases. I have yet to meet even one other defendant who was able to afford to hire a private investigator to question their jurors after their trial as I did in my case. This is why the public trust in trial judges to properly record such inquiries is so sacrosanct. It is likely I have been the only defendant in Judge Watkins' courtroom who has been able to afford such scrutiny. And what are the chances this rare scrutiny just so happened to be his only case where such a grievous error occurred? I would argue the chances are extremely low. Likewise, why wouldn't state prosecutors take advantage of this opportunity to present additional information to other juries off the record in this way in every other case in Judge Watkins' courtroom? It is no secret every prosecutor wants to win every case they pursue. It is clearly advantageous for them to be able to completely avoid the rules of evidence and appellate review by secretly presenting anything they want to the jury during deliberation in order to secure a guilty verdict, even if the quote-unquote evidence is inadmissible and or altered as it was in my case. The affidavit from my juror proves the official trial records of Judge Watkins' trials cannot be trusted to reflect such extrajudicial presentations to juries in his cases. The only way for anyone to find out if my trial was the only one in Judge Watkins' courtroom where this happened is for all of the jurors from his other trials, or at least a large random sample, to be tracked down and asked if any unrecorded request, question, or presentation occurred during the deliberations in their cases. I believe the judiciary committees are the only state entities left in the Tennessee government with the capacity and political independence to undertake such a necessary and immense effort. Why the legislature needs to act on this complaint. I realize the legislature's first reaction to this letter may be to tell me to play out my grievance through the court system, so as to respect the government's separation of powers. I respectfully argue I have done so already. While it is true I am currently still fighting my case through my federal habeas petition, I have exhausted every possible avenue of relief through the state executive and judicial branches. Furthermore, this letter is not simply about my case. It is intended to be a whistleblower complaint about Judge Watkins' illegal and secretive jury tampering, which may very well be ongoing in current and future cases. Not only do his actions violate the constitutional rights of defendants in his courtroom, they are, in fact, crimes. Imagine if I snuck back into the jury room during deliberations and played edited DVDs for the jury, which were not played during the trial, and then lied about it when asked about it in court. I would be rightly charged with jury tampering, contempt of court, perjury, and obstruction of justice. Why is Judge Watkins immune from these charges? Just because he adjudicates the law does not mean he is above it. If he truly believed this presentation was legal, then why didn't he record it on the record, or inform my trial attorney about it, or at least correct the record at my 2014 post-conviction hearing when it was explained to him that the lack of request on the record was the basis for the appellate court's denial of my 2013 direct appeal? He knew it was wrong when he did it. He knew it was wrong in 2014 when he covered it up. And he obstinately dismissed my error coram nobis petition where I proved he had committed these acts because according to him I should have somehow known about the juror request earlier, even though he was the reason it was unreported and unrecorded. Even more disturbing is the way the appellate court accepted Judge Watkins' denial of my error coram nobis petition on the basis that I, quote, unquote, should have appealed his actions earlier in my post-convictions appeal. This was the court's opinion even though I was unaware of the existence of the verbal request until after my post-conviction hearing and appeal, 5 years after my trial. All three of my state appellate court rulings ruled it was my responsibility to somehow know about a jury request that occurred only in the jury room where I was not allowed to be. How is it my responsibility to appeal a request that Judge Watkins never told me or my trial lawyer about? If you read the 2018 appellate opinion denying my error coram nobis petition, you will see the appellate court would not even consider the fact my jury foreman's affidavit proved my jury was exposed to information, the contents of the videos, which was not presented during my trial. I am not trying to ascribe motives in this letter, but it is difficult to ignore the question of why the appellate court would so easily disregard such strong evidence as I was denied the ability to confront, object to, cross-examine, or appeal the evidence used against me to secure my conviction and imprisonment. These rights are guaranteed to all defendants in Article 1, Section 9 of the Tennessee State Constitution and the Sixth Amendment of the United States Constitution. The post-trial record from my case demonstrates the Tennessee Appellate and Supreme Courts accept that off-the-record presentations of extraneous information to juries are lawful. They effectively also accept that a judge's failure to enshrine such a presentation on trial record is a tolerable policy. As I understand it, the state legislature has constitutional oversight responsibility over the other two branches of state government, including the appellate and Supreme Courts. The court opinions and affidavit in your hand should be more than a strong enough proffer for you to at least inquire into the integrity of this state's judicial process. Judge Watkins took these improper actions completely outside of the court record, which apparently neutered the ability of the judicial branch to even review, much less scrutinize, the unconstitutional process that led to my loss of freedom. This situation evidently necessitates a higher level of oversight than the Tennessee appellate process can provide. How effective is a judicial branch that not only allows something like this to occur, but also does not provide an effective remedy for such an egregious violation of a defendant's basic constitutional rights? All of the incarcerated defendants from Judge Watkins' jury trials, including myself, are Tennessee residents, whether voluntarily or not. What else does the Tennessee legislature stand for if not first to defend the civil rights of Tennessee citizens? Furthermore, the legislature allocates millions of dollars of Tennessee taxpayer money to finance the operations of Judge Watkins' courtroom. The judiciary committees have a duty to ensure taxpayer money is not funding the illegal and unconstitutional jury tampering by state employees outlined in this complaint and proven by my foreman's affidavit. Tennessee taxpayers have the right to transparency regarding what trial judges do with their tax money behind closed chamber doors. I believe you should at least ask Judge Watkins and the Davidson County DA these two questions. 1. Were there any videos played in the courtroom during the October 2011 trial of Timothy Guilfoy? 2. Were there any videos played for the jury during the deliberation of that case? Of course, you already know the answer to these questions. You should ask them. 3. How is it possible that this presentation was not enshrined on the trial record? And also, 4. How many other trials in Judge Watkins' courtroom have included similar off-the-record presentations of extraneous information to a jury during deliberations? Whatever explanation or justification they may give you does not change the fact that I am sitting in prison for the last 9 years and for the next few decades, and I have never even seen the evidence that was used to convict me. Is this acceptable to you? Is this anything short of outrageous? Do you actually believe in due process? What will you tell your constituents when they ask you if this could happen to them? Please help. Even considering what I have been through, I still believe there are honest people in this state who actually believe in the Constitution. At the very least, I will now be able to say I have given every oversight structure in this state an opportunity to right this wrong. I refuse to believe we live in a society where it is acceptable that secret evidence is secretly presented to juries to convict innocent people or even guilty people. If you need any further information, including transcripts, briefs, rulings, or juror interviews, please contact me or my sister, Katie Byers, at kathleenbbyers@gmail.com. This situation will not simply go away if the legislature ignores it. My juror's affidavit is incontrovertible evidence of my accusation's validity, and my supporters and I will be presenting it to as many Tennessee citizens as possible until something is done to honestly address it. Whether Judge Watkins' actions were due to incompetence, malice, corruption, action needs to be taken immediately before another innocent person is convicted due to a secret presentation of extraneous evidence to a jury in another one of his trials. Please initiate an inquiry now. Please help me. Please stop Judge Watkins from tampering with any other jury. Please uphold your oath and defend our Constitution. Sincerely, Timothy Patrick Guilfoy. If you would like to help Tim, please visit www.freetimg.com/fight. Be part of the wave of support that helps to bring Tim home. Be part of the wave of support that frees an innocent man.
Please go to www.freetimg.com and download the two-part podcast, Innocence in Nashville, the Tim Guilfoy story. You will hear interviews from many people close to Tim and close to this case. You will also hear from Tim himself. Here's just a sample.
So, Bob, when and how did you meet Tim?
Oh, well, Tim Guilfoy and his family moved in across the street from where I grew up the summer we turned 5, and, we were inseparable.
So what was Tim like as a student at Vianney? Was he a good student? Was he rambunctious? Kind of how was he as a student?
Academically, I would say he was, well above average, probably a B plus at his worst. As far as, social interaction around school and things like that, he had no trouble fitting in with, any number of groups. He played football, whatever. I believe he had a poker circle of a couple of dudes. He was busy working most of the time. So anything he lacked socially, I think, was because he was at 14 already working about 40 hours a week. So he was one of the few guys, probably the only guy I knew, who actually owned his own car. And that took place, I think, here again, before he was legally able to drive. So the guy had a car to his name before he turned 16. That alone tells a story.
Tim, during Prosecutor Roger Moore's closing arguments, he told the jury that they were not the same social status as you. Why do you think Prosecutor Moore said that you were of a higher social status?
Well, from where I was sitting, they didn't have evidence to argue, so they tried to make the jury think that I was some rich kid hanging out with someone from a lower class only to get close to their children or something like that.
Would you consider Tim and his family wealthy?
They're a middle-class family. It's not like we were given all of the latest and coolest everything.
Mm-hmm.
We really had to go out and work for that.
How did it come about that Jen rented a house from you?
Well, so in May 2008, I was looking at multiple different cities to possibly buy a house to rent out.
So would you say that he was naive with people when he would first meet them?
I don't know if naive's the word. I think he just looks for the best in people, and maybe that is naive.
Mm-hmm.
Like, Tim was wise with his money, and he wanted to invest in solvent businesses. And he saw real estate as a solvent business. So rental properties were the first step for him.
In May of 2008, I actually went on a camping trip with Jen and her family. And after that camping trip, she sat me down and she said, I want to stop using drugs, stop drinking. I need to get my life together. I need to get more education. I remember her distinctly saying, I want to show my girls what a real woman does. And the problem was is that she had no rental history. She didn't have savings. She was living off of $1,000 a month child support that she got from the state of Florida, I think, from her ex-husband. And she didn't have enough money for security deposit last month, all that stuff. She knew I was looking for a house to rent out, and she proposed to me that I would buy a house and rent it to her.
Knowing Tim and knowing Jen, where do you come down on the case? What do you think happened? I mean,
it was always a conflicting issue. When I first heard the case, we were always all quick to quickly demonize Tim. How can he do that to innocent little girls? And it was just as more and more time passed, it just nothing seemed right. It didn't seem like I know myself never saw any evidence. The only evidence I was ever told of was a phone call that was supposedly his admittance on the call while it was being secretly taped. That was the only evidence I've ever heard of. That was it. So at face value, we accepted that for quite a long time, several of us that know them. And we were quick to demonize Tim on it. Maybe not so much myself, but as so much just to dismiss it. Mm-hmm. Well, that's what happens. You do that, you get this. But we always discussed that I remember one time Andy was telling me, he goes, but the video that she got, the audio, he admitted it. I'll never forget saying to him, I was like, but did you hear it? No, I never heard it. Was there any other evidence presented to you that would make you think otherwise? Well, not really, but she said she had audio. I agree. I heard she said she had audio, but I've never heard audio. I never directly heard from Tim that he said he did this. So we discussed it several times. There was enough, though, and I do remember that when speaking with them, and I will go to say as far as I remember saying, guys do know Jen's kind of shady. Could you put it past her to do this? And that's where I could see her doing, maybe getting out of control, but that sounds like maybe something Jen was working an angle. She kind of is a person who's a little on the sly side. So what I do truly believe is what happened was that Jennifer was in a bad situation. She found someone who was in a good situation, kind of latched on to him. As things started going south in the relationship, accusations were brought up. I don't think she intended it for it to go this far, but she got into a point where it's either we go forward or you face the consequences of lying. And at that point, self-preservation became the motivation.
Would you consider Tim an honest person?
Yes. Tim is one of the most honest guys I know. I've known him since I was 5, and he's 100% solid. I know I can trust him.
So at any point when you were growing up and you were the same age as these girls that Tim allegedly assaulted, is there anything that Tim ever has done that could have been seen as a sexual assault upon you?
Absolutely not. I don't even think he ever reached to hug me. I don't think he ever, or I don't recall him ever putting his hands on me in general, or him ever getting too close to me. He understood the boundary of him being an older adult figure in my life, and understood that it was his job to make sure that I felt safe. And I think he took that very seriously. I remember my dad asking me about it, and I was so confused because I was just like, what do you mean? It's Tim. Tim would literally never.
Please go to www.freetimg.com to download this podcast. And remember, share Tim's story with anyone you know who cares about justice and freedom.